Right from the start, we know this isn't just another docket call. 2 serious charges, including capital murder. Judge West is about to navigate a legal minefield, and everyone in this courtroom knows it. The judge wastes no time reminding both sides about the Michael Morton Act, Texas's safeguard against hidden. Good
morning, sir. You're Larry Williams?
Yes, ma'am.
And so we've got 2 cases with Mr. Williams. Cause number 25 DCCR 0985. Mr. Williams is charged with capital murder. And Mr. Cashion, you represent him on that case.
Yes, Your Honor.
Mr. Johns was hired to represent Mr. Williams in cause number 24 DCCR 1790, which is the aggravated assault causing serious bodily injury.
Yes, ma'am.
We're here today on an announcement. Mr. Cashion has filed several motions, and so a couple of things that I feel like we could probably handle today, and then a few things that I'm going to put off to another day. Most of those motions I think were filed Friday.
Yes,
Mr. Smith is the Assistant District Attorney on the case. You can talk with Ms. Malfino this morning. She'll kind of fill you in on how I guess let me go through the first thing with regard to discovery.
Yes.
And how you get that here. There's a portal. It's very easy. The state is very easy to deal with. They'll give you access to that portal. If there's any media in the case, there's a different request that needs to be made for that. Ms. Malfino can sit with you this morning and explain how all of that goes.
Yes.
So with regard to it this time,
Here's where it gets spicy. A motion for a gag order, basically a muzzle on public commentary, always raises eyebrows. Judges tread carefully here because it bumps right into free speech territory. What a session. Procedural
discovery. I'm not going to rule on any discovery motions. It's automatic. It's Michael Morton Act and everything else makes it where they're going to give you everything they've got.
Yes.
And so if you find after you visit with them and you get everything off the portal that you feel like there is something that's missing, then bring it to my attention, bring it to their attention first, obviously. And if there's an issue that you feel like you're entitled to something that they're not turning over, then we can have a hearing on that at that time. So the next thing that I do want to go through and rule on, at least today, is that
mastery, constitutional restraint, and a dose of courtroom realism. Judge West proved once again why she's the calm in the storm, even when capital murder, media, and clerical chaos collide. Listen closely, this is constitutional chess. The judge knows gag orders against non-partis, like a sheriff, are a legal gray zone.
For a gag order that was filed some time ago, and so everybody's had a time to take a look at that. I'm going to, Ms. Malfino, I guess let's start with you. Obviously, I understand Mr. Cashion's position with regard to that and his motion. What's your position?
I do as well, Judge, and I think the court is aware, as long as you've known me, myself, and Mr. Smith, it's always our best practice policy not to speak to the media or anybody while a case is pending. If that, I have no objection to that order, and if it is granted, I will be sure to send out a memorandum to my office, letting them know it has been granted and that they need to come.
Sure, and I don't have an issue with the district attorney's office. The only issue that I have is the sheriff's office.
Yes, ma'am.
Because I don't think the sheriff. Typically, as everybody knows, gag orders are not deemed constitutional.
She's threading the needle between fairness and the First Amendment. A typo in a capital murder indictment? That's not small potatoes. Even a single wrong code section can become a pellet ammunition later.
Obviously, there's exceptions, and Ms. Malfino agrees in this case with regard to her office. I will gladly ask the sheriff's office, but I don't think I'm in a position to order them. They are not a party, as the attorneys are, and so I'll let you make argument if you'd like, but I'm not inclined to grant a gag order on someone that's not a party. I don't think constitutionally I can do that.
I understand, but I just wanted to point out to the court that certain people in the sheriff's departments, I think they have podcasts and they go on the media and then they give their opinion about this case that is presently pending, which I kind of think taints the jury pool if we end up in a trial. And
do you know who that is? Somebody who has a podcast currently about this case?
Well, I've seen sheriffs speaking about this case on different podcasts. If I need to be specific, I will locate those particular, or that particular.
If you don't mind doing that, and you
Yes,
can,
ma'am.
if you would, you can just email myself and Ms.
Yes.
Malfino, Mr. Smith, because I don't mind at least starting with a request to them not to do
Yes,
it.
ma'am.
If I feel like what they're doing is in some way going to be detrimental to us being able to get a jury,
Yes, ma'am.
then I will look more into that. I don't know, again, the constitutionality of it. I would have them probably show up to a hearing with their legal representatives, and we can handle it that way.
Yes, ma'am.
So let's do that. At this point, I'll grant the motion in part with regard to the district attorney's office, and obviously with regard to you, Mr. Johns, and anybody and everybody's, y'all's respective offices. And then send me that and whatever information you can find.
Yes.
I'll talk to the sheriff's office. I have a feeling they won't have any issue with my request. And so, but if they do, then we'll talk more about that. So then that's that.
Also, Your Honor, I think, which, some housekeeping matters that I think are rather important is in regards to the indictment and the way the indictment.
Yes, so you filed a motion to quash the indictment.
Yes, ma'am.
I did take a look at that. I honestly saw the same issue already with the indictment.
Yes, ma'am.
The style or the heading of the indictment
Yes, ma'am.
legally is not necessarily indicative of the most important part, or it doesn't, what's the word? The body of the indictment sounds correct in this case.
That is true.
The state has become aware of that. It should say A2 instead of
Yes,
A10.
ma'am. Yes, ma'am.
They are going to get that taken care of, and so that way it looks correct.
Yes,
It's correct, obviously, in our system as well, which
Yes.
can become an issue just because of our system.
And I just wanted to be correct.
I totally agree.
And Judge West is making sure this case leaves no loose ends. This part's fascinating for legal nerds. The defense wants officer personal notes. But those often fall under work product privilege, meaning they're protected.
And that's the only issue, was the A10 to A2, correct?
Yes, ma'am.
Okay.
Yeah, that's rather important.
It is. The body, though, I
It's
did read the
fine.
body, and it looks like there's not an issue, but we'll make sure that the Ms. Malfino.
And Judge, having not worked with this gentleman previously, I would be happy to make an oral motion to amend if you would prefer.
It
That
doesn't
we
matter.
follow that up with a written motion, just so it's cleaner for the court.
I think
happy to
I'd
do that
rather,
as well.
just because of the nature of the offense,
Sure.
because it's a capital, if we just do that, if y'all would do a motion in writing. And that way, we've got a paper trail
Yes.
in the file that shows there was a motion that's and I'll grant that and
Yes.
make that adjustment on the
I
indictment.
just wanted to be accurate.
I don't disagree with that at all. So they'll get that taken care of, I'm sure, very soon.
It'll be e-filed, sir, so
Okay.
if we can exchange emails,
So
I can
fine.
be sure
We'll
that
do
it's
that
served.
after we conclude.
It looks like the other things that were filed have to do with mostly discovery issues, a list of persons to contact or interview, some
Yes,
things
and
like that.
That to me, Your Honor, is important because after reading the probable cause affidavit that's attached, it indicates a lot of he said this and she said that, and
That's one of those things that I would say, get with the district attorney's
Yes, ma'am.
office. Obviously, I would think anyone that any detectives or officers talk to or interview
Yes,
would
ma'am.
be part of required discovery.
and I would like that, like kind of like early on instead of later on, because those people
Well,
need to be interviewed.
Sure, I mean, whatever they have, you'll get.
Thank you.
And then if there's anything, again, that you feel like is not included,
I will
bring that to their attention first.
Yes, ma'am.
Let them contact the agency,
Yes,
see where that stuff is and how quickly they can get it. And then if it becomes an issue, let's get back on that.
Yes, sir.
The last thing that I see that I'm not there's a motion for preservation of personal notes.
For the officers, the police officers.
Okay. Ms. Malfino, have you had an opportunity to take a look at that? I really haven't, as far as,
Really haven't, Judge. I know that.
I would think
you know,
personal notes might fall into some type of
of
work product. I mean,
Yes.
their reports
if
obviously
something
will
was
be turned over.
exculpatory, Yes, I would agree that, that information be turned over. I would assume it would have then been placed into a report.
Right.
At some
Mr.
point, I
Cashion?
would argue that some of that is work product, personal notes of correspondence between us and the officers in preparation, et cetera. I would argue as work product.
To me, the personal notes are attached to the people that have been interviewed, because the officers, when they go out and interview people, they may take personal notes, because in the probable cause indictment, it said that they had spoken with certain people who said that he had a gun on a particular occasion, certain people that said he did it, and those are the people that need to be interviewed, and the personal notes of the officer relates to those things.
And Judge, if I may, I think he may find when he requests the media that majority of those interviews
On
might
body
possibly
cam.
be on body cam or having someone come into the police department.
Right.
It's not so common practice anymore for the transcript, so to speak, of that interview to be recited then in a report. So it may reflect in the report, I spoke to X, and he hasn't seen the recorded interview, which would obviously make a big difference.
Okay.
But that's the type of information I was leaning toward.
Sure. And I think that's probably, let's do
And
this.
with the nature of the case, I need to cover my bases.
Absolutely. No. Yeah, I would.
The judge is wisely waiting to see if those notes even exist outside body cam footage. A quick but crucial move, delaying the bond hearing gives both sides breathing room, especially the prosecution. It shows Judge West's balance.
Totally agree. So today what I'm going to do is hold making a ruling on the motion for preservation of personal notes. The motion for discovery, obviously,
Yes.
that's
Yes, ma'am.
granted. You
Yes,
get
ma'am.
you get all of that. Work with them. Anything in the person's interviewed. Let's go through the discovery process
Yes.
first. The way with the portal and everything. If there's anything that comes up that you feel like you're entitled to that they are refusing, then we'll have a hearing about that and work that out. The last thing is there.
Firm control but fair play. What a session, procedural mastery, constitutional restraint, and a dose of courtroom realism. Judge West proved once again why she's the calm in the storm, even when capital murder, media, and clerical chaos collide.
There's a motion to reduce bond that was filed on Friday.
Yes, ma'am.
And so, Ms. Malfino, I'm going to ask, is the state ready to proceed on that today, or do you need some time or to get Mr. Smith available on that one?
Well, and I'm happy to cover it, Judge. I don't need a lot of time. I would prefer the ability to get at least the lead detective here for the court. In
Sure.
the instance that you or counsel would have any questions with respect to that. I'm not necessarily saying we're opposed to some type of relief. I know what the bond is set at now, but I think due to the nature of the case,
Sure.
as counsel has stated as well, I think it might be beneficial to have just a very short hearing. I can be prepared on that as early as next Tuesday, Judge.
Okay, so Mr. Cashion, we can do a couple things. I think just because it was filed kind of late in the game,
Yes,
I want to give them just a short amount of time
Yes.
to get prepared on that. We typically have Tuesdays are our jail dockets. I'll be in.
Or maybe the next week, since we're going to be in trial next Tuesday, we won't the following week because of Labor Day.
Right.
That would be great.
Mr. Cashion, I'll let you choose next Tuesday or the Tuesday after.
Maybe on my calendar right quick.
We could do it next Tuesday. Do we have one already set at 11 next Tuesday? We'll do a lot of these types of things at the end of our Tuesday dockets. We might have something already. We do not. So we could do it either or next Tuesday or the Tuesday after.
Tuesday afterwards might be better. September 2nd.
September 2nd?
Yes, that'll work better for me because I have several matters next
Sure.
Tuesday.
Okay, then we will set the motion to reduce bond on the 2nd. And if anything comes up between now and then, we can discuss all that as well. And especially if, Mr. Cashion, if something comes up after I visit with the sheriff's office with regard to any information that you emailed to us,
Yes, ma'am.
then we can maybe have them here on that day possibly to take care of that part. But right now I am granting the part of the motion for gag order on the attorneys only.
Yes, ma'am.
Okay? Anything else we need to handle today?
I think that covers
The
it.
status of my case with them. Prior to these new allegations, we had come to a proposed plea bargain agreement, Ms. Smith.
I won't, at this point, I don't think it's appropriate for me. I'm not going to accept any plea agreements
I
on that
understand
case.
I'm just kind of giving you the background.
Sure.
Let you know, I have been talking to Mr. Smith. I talked to him last week in reference to this case, some of the suggestions that he made to me. I really don't know where to go forward with this situation. So I would ask for more time and see what's going on.
I think that, sure, and I think what we'll do is carry the two, they're obviously not on the same date, cases, but they're related, and so the cases will be carried together on all of the dockets, and if, on next Tuesday, or the Tuesday after, that's really a motion that Mr. Cashion has filed that we're gonna handle. If you want to be here for that, you're welcome to. I don't think legally you haven't filed anything that we would be hearing on that day. It would be the bond reduction. But typically on announcements and as we're preparing to move forward in the case, I would expect you both to be here. Both cases will kind of travel together, and then we'll see where we get.
To add to that, I appreciate you saying I don't have to be here next Tuesday. I'm in a stage in my life with my mother. I'm blessed to have my mother at 94 years old, and you probably can make an anecdotal effect that I'm pretty much steady going to be in court when I'm supposed to be in court, but because of that I'm having some issues and I'm not getting where I need to be getting it. The secretary's gone, so I'm having a few little anecdotal issues right now, which I haven't had the last 30 years.
We'll make sure, again, on the second, you don't need to be here on that one. After that, you'll get notice of obviously every announcement and things like that. And so if you're having an issue, just let us know. If it's something that's just an announcement, it may be something that you can visit with Mr. Cashion. If there's nothing that's taking place and you're having an issue, we can still move forward, at least with moving the cases along. All right.
Thank you, Your Honor.
Thank you.
There's one other thing that in